Welcome to Comply on the Fly with M3 and Karen B, your trusted resource for quick, reliable insights into employee benefits compliance. Each episode delivers clear answers to common compliance questions. Whether you're tuning in for the first time or you're a seasoned listener, we're here every other week to make navigating compliance a little easier. Please note this podcast and the contents herein do not constitute legal advice. In all cases, employers should consult with their own legal counsel. Let's dive in.
Hello, everyone. I'm Karen B, and the Comply on the Fly topic for today is Minnesota paid leave. I'm once again joined by Alex O'Connor, a compliance attorney on my team. Alex has been staying on top of the requirements and has the following to share.
As the countdown to Minnesota paid leave nears zero, we've been seeing some common questions from employers that we'd like to address for everyone to hear. We have been seeing a lot of questions related to how paid time off, vacation time, and paid sick leave interacts with Minnesota paid leave. You as the employer are responsible for determining how any paid leave you offer interacts with Minnesota paid leave. As a reminder, Minnesota paid leave provides employees with partial income replacement, but does not replace 100% of their wages. You are able to decide if employees can top off payments for Minnesota paid leave, which is using any available paid leave from their employer. Topping off happens when an employer designates their paid leave benefits as supplemental benefits. If you want to allow an employee to top off their Minnesota paid leave benefits, you must designate your paid leave benefits as supplemental benefits. However, you are not required to permit employees to top off their Minnesota paid leave benefits. If you do not permit the topping off of benefits, an employee will need to use any employer paid leave to get 100% of their income replaced and will not receive payments from Minnesota paid leave for the days they are receiving 100% of their income replacements. Another question we are seeing quite frequently is from people who missed the November 15th deadline to apply for a private plan exception. They are curious if they are out of compliance with Minnesota paid leave. The answer is no. If you missed the November 15th, 2025 deadline to apply for a private plan exception in Minnesota, you are still in compliance with Minnesota paid leave as long as you follow the steps to comply with the state plan by January 1st, 2026. You are able to implement a private plan at the beginning of any quarter. So come April 1, 2026, you can apply for an exception again and have that private plan exception go into effect. Another question we're receiving a lot is what notices need to be provided to employees. Employers have to provide employees with a Minnesota paid leave notice by December 1st, 2025, and post a Minnesota paid leave poster for employees. There are model notices and posters available for these purposes, but please note there are different notices and posters if you are using the state plan or have a private plan exception. Employers are supposed to get the notice acknowledged by employees. This acknowledgement could be a physical signature, an electronic acknowledgement, or any other acknowledgement method you deem reasonable. Distribution of the notice should be tracked in case an employee refuses to sign the notice. We're also seeing some questions regarding how short-term disability plans interact with Minnesota paid leave. The state of Minnesota will not be reducing any Minnesota paid leave benefits just because an employee is also receiving short-term disability policy income. However, while the state will not reduce its benefits, short-term disability policy insurance carriers are able to and often will reduce the benefits they provide. It's important to coordinate with your short-term disability carrier to understand how your short-term disability payments interact with Minnesota paid leave. Finally, we're receiving a lot of questions regarding how Minnesota paid leave interacts with other leaves like federal family and medical leave. Minnesota paid family and medical leave, also known as Minnesota paid leave, is going to run concurrently with other forms of leave, including federal FMLA leave, if the reason for leave applies under both laws. That being said, there are situations where leave is only going to apply under Minnesota paid leave. And in that situation, someone could continue to take federal family and medical leave if they had a qualifying reason at any point in the next 12 months.
Wow, Alex, thank you. That was a lot of great information as we approach the implementation of Minnesota paid leave. Thank you so much for the insights. And as always, you can contact M3 Compliance if you have any specific questions. And that is your Comply on the Fly topic for today. Thanks for tuning in.
For more employee benefits compliance insights from Karen B and her team, please visit m3ins.com.